Hello, my name is Crystal Dahl, and I am the Online Communications Manager here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar, Compliance from a Data Protection and Labor Perspective. For those of you that are new to Meritas, Meritas is an established global alliance of closely connected yet independent law firms that each offer a full range of high-quality, specialized legal services. We were built upon a rigorous system for monitoring and enhancing the quality of our member firms, and we have been connecting clients with carefully qualified business legal expertise in over 240 markets around the world since 1990. Meritas Capability webinars are regularly presented by Meritas members. Before we get started, I would like to quickly go over a few housekeeping items. Meritas offers the ability to listen to our presentations through your computer speakers. But if at any time you have any difficulty hearing the presentation, you may call into the associated telephone line instead. All phone lines will be muted. If you experience any technical difficulties, please press *0 at any time to connect with the support technician. Otherwise, I can help if you send a chat message. Since you will be muted, if you have a question, please ask via the chat feature found on the left-hand side of your screen. Carlos and Javier plan to answer questions throughout the presentation, but in the event they are unable to answer all the questions, they can reach out to you individually as well. Lastly, in the next few days, I will distribute a copy of the presentation, a recording of the webinar, as well as the presenter's contact details. Our presenters today come from the Meritas member firm in Mexico, Cuesta Campos. Carlos is the Director of the Labor and Employment Practice at Cuesta Campos in their Mexico City office. He represents Mexican and multinational companies in all kinds of labor and employment matters, advising on the employment aspects of major transactions such as mergers and acquisitions, restructurings, labor law work, such as collective bargaining and employee benefits related engagements such as incentive plans for senior executives. He designs strategies for labor terminations that reduce the risk of litigation for the company and save clients money. Javier is the Director of the Compliance Practice at Cuesta Campos. Having strong experience on intellectual property law, IT, commercial transactions, and corporate law, he also advises clients on regulatory matters, including public bidding processes. He has advised domestic and multinational clients in the drafting and implementation of compliance programs to identify and reduce risks. His work in compliance matters includes anti-corruption programs and investigations, including FCPA and UKBA, implementation of data protection programs, confidentiality, as well as support and legal advice and inspections from administrative authorities and in public bids. With that, Javier, are you ready to get started?
Yes, Crystal, thank you very much for the introduction. So if you don't have anything more, we can get started.
Yes, please go ahead.
Okay, thank you very much to all of you that are attending this webinar. I will be trying to be very concise as to the aspects we intend to cover with this presentation. We will be trying also to answer all your questions during the presentation. However, as Crystal mentioned, if we are not able to answer all the questions, we'll be responding to you directly after the conclusion of the webinar. So I think let's get started. First of all, it's important to understand what is compliance and what are the purposes of implementing a proper compliance program from a data protection and from a labor standpoint. What are the risks, what are the benefits of having this type of compliance programs? First of all, we can say that compliance will help companies to meet their corresponding needs according to the risks assessments that they have conducted in order to cover all the needs for the business. This with the intention to avoid risk associated to the different aspects of the operations of the company. Through a proper compliance program, we can allow the company to meet compliance with applicable laws in the relevant country in which you are having operations, and also to comply with internal policies that the company wants its employees to meet. And this can go over the specific and mandatory regulations that are applicable on the relevant country. So when we talk about compliance, obviously, we're talking about many areas of expertise. For example, you can see here in the presentation different aspects where compliance can apply to the operation of the company. These are some of the most relevant subjects where we recommend to have, even though regardless of the specific needs of each company, all companies have in a certain way needs on data protection, privacy, security of information, prevention of corruption, etc. And as you may know, currently Mexico, in the past, I would say in the past 6 or 5 years, our authorities have been issuing several new laws that intend to push companies to look for compliance. Perhaps 6 years ago, not all the companies had to think on compliance programs, and though, however, operating in Mexico without proper compliance programs nowadays, will certainly put your company into a risky situation. One of the most important relevant amendments to laws was the issuance of the National Anti-Corruption System, obviously, which implies that all companies should have an integrity program in order to prevent corruption, among other things. And we will see that this integrity program will certainly impact on labor and data protection aspects. For example, what type of employees we are hiring, what type of information we can request from our candidates. For example, if we are hiring our CFO, or if we are hiring a manager that will have contact with governmental authorities, do we need to conduct a deeper background check on this employee, on this candidate or not? Can we do that? What are the implications on the information we are requesting to conduct this background check? Because the National Anti-Corruption System and having an integrity program implies that you need to check who you are hiring in key positions, for example, to avoid corruption risks, to say something. So what are the key points that we consider when we are deciding if we are going to have, or what is the extent of our compliance program? Is that if we do not meet at least the minimum requirements of law according to the business sector we are operating on, we can have as a company an economic impact, obviously, due to the fact that we might face infringement proceedings by all type of authorities, criminal, data protection, confidentiality, anti-corruption, etc. So we can have an economic impact by the sanctions that the authorities might set for the lack of compliance with our obligations as a company. We can also have reputational impact and image impact on the company, which in many cases, this can be harder than the economic impact of facing a fine or something from an authority. What are some examples of some good corporate practice? For example, depending on the specific needs of your company, it is important to assess if we need to create a compliance department. This compliance department can be as small or as big as the business requires it. Some companies perhaps will not have a many impact with governmental authorities, for example, and so we need to assess what are our risks, and in considering our risk assessment, we need to determine how we will be creating our compliance department. Obviously, we need to have the compliance department, and that compliance department will have an important function, which is generating culture based on integrity and ethics. We need all the employees of our institution, of our organization, to understand that the operations of the company are based on integrity and ethics. Obviously, the involvement of the management committee on a real manner is of the utmost importance for this type of matters, on the implementation of the compliance department, the policies, the communication of the policies. And though the management committee must be involved in relevant compliance cases, needs to be involved on the risk assessments, on how the compliance programs are being implemented, and in that sense, the management committee must make decisions in the sense of improvements, modifications, etc. And obviously, it is important to create tailor-made policies to the needs of your company. These policies need to be communicated and need to be socialized within the organization. Otherwise, it won't be helpful just to have a document that is not actually applied. And we will address on a couple of minutes the fact that, for example, if I might have a very good anti-corruption policy, but if I'm not able to prove, for example, that I conducted certain trainings with key managers or key employees that are the ones that are more exposed to corruption situations, and that they are not aware of the existence or the content of the policy, then authorities might say, hey, okay, you have this policy, that's nice, but this policy is not socialized by the organization, so it's just useless. What are the steps to define or to identify how we will be implementing our internal compliance program? First of all, we need to identify what are our risks as a company, what are the legal frameworks that apply to our operations. Once we have that risk assessment, obviously we need to start implementing specific policies, programs, processes in order to seek compliance with laws, compliance with national laws, obviously, international regulations or regulations from other countries that might impact also our operations. For example, FCPA, UK Bribery Act. We all have heard of those type of regulations. And we will be starting to generate these programs and policies. This in order to prevent risks. Compliance is about preventing that in the future we won't have as much problems as we could have if we are not training our people, if we don't have a proper program to prevent corrupt acts, breaches of information, etc. And one of the most important parts, obviously, and I have already mentioned this, is once you have your risk assessment, you have taken certain measures to implement your compliance department, your programs and policies, you need to conduct proper trainings, communication programs, so that all the organization understands and is aware of what the company wants in terms of compliance. Some of the most important policies that are generally recommended, for example, data protection, security of information, antitrust, bring your own device and tools. This is one of the most important for our presentation today. Why? Because in many cases, in many companies, for example, there are two options. They can give directly to the employee the working tools that the employee will be requiring for conducting his functions within the company, or we can allow the employee to bring his own device. This is his own cell phone, his own computer. And though when we are doing this or when we are allowing this type of situations, what we need to ask ourselves is, for example, if I have a breach of security, what can I do? If it's the employee cell phone or computer, can we review that computer? Can we conduct an investigation over the communications contained on that computer? There is a big difference between allowing the employee to bring his own computer or giving the employee a company's computer. And we will address these items during these presentations. Obviously, labor terminations, gifts, etc. All these policies implies and impact the labor life of an employee within an organization. So, what are for starters, from a data protection standpoint, what are the main recommendations from a data protection and a labor standpoint? First of all, we are all aware, for example, that if we're obtaining personal information from any individual, we need to have a proper privacy policy to rule the processing of the information of those individuals. And we need to have specifically here in Mexico a document that is called a privacy notice. This privacy notice will inform individuals of the specific purposes for which the information will be used. So first of all, when we are recruiting individuals for a certain position within our company, then we need to have a privacy notice that will rule the information that we will collect from all the candidates that we will be interviewing. It is important to consider that you cannot request any information that you like or you want. We need to think when implementing recruitment processes, we need to think of the information that we will require from the candidate for the process, considering that information is proportional for what we are doing. And we need to take care that the information that we are requesting or asking does not give place to discrimination acts, because this might lead obviously to conflict with certain labor authorities, etc. However, we need to seek the balance between what information we can ask that not implies that we are discriminating individuals without any reason, or requesting information that is not strictly necessary for the recruitment process. And we need to have the balance with the obligation we have as a company to actually review and verify that we are hiring the proper candidate for some specific position. For example, it will not be the same the information that I might be able to request from a maintenance employee rather than an employee perhaps that will be managing our governmental relationships. It is justified, for example, to look for more information from the manager that will be managing the governmental relationships. It is justified to request additional information or to try to know better that individual in order to know that that individual does not imply an important risk as to the position that he will be managing. So, this obviously, all the data that you require during your recruitment process must be set forth on the privacy notice. And you might require more or less information depending on the specific position for which you are recruiting. So, once you have concluded all the recruitment process, and our recommendation is obviously to have a proper recruitment process duly documented that assists your HR departments on what they can and cannot do, or how to handle certain specific situations. A recruitment policy is very helpful in these cases. But we have already chosen our candidate. Then what comes next is obviously the formalization of the employment relationship. So when we formalize the employment relationship, it is no longer a candidate, it will be a formal employee of the company. So with the documents that we will need to execute with that new employee, we will also have to execute a privacy notice specifically to rule the use of his information, not as candidate, but as an employee of the company. Because the purposes for which we use the information are different. And we will see that in this privacy notice, we can set certain specific consents and rules that will allow us in the future to properly be able to conduct certain, for example, compliance investigations. Let's think, for example, if we have, through our whistleblower channel, we have a claim that perhaps some employee committed corruption acts with a governmental officer. So what we need to do, according to the compliance program of each company, is to conduct an investigation in order to identify whether this information is true or not. So we will see what happens when we have the consent of the employee and when we do not have the consent of the employee for this type of situations. Obviously, in addition to the privacy notice, either with candidates and with employees, with an employee, it is important to execute the individual employment contract with confidentiality clauses and data protection, plus what I was referring to, monitor working tools. This will inform the employee that when we give the employee certain specific working tool, this is a cell phone, a computer, etc. This implies that we are letting that employee know that that is a tool property of the company and that must be used exclusively for the purposes of the job, not for anything else. And we're informing that the company might or might not monitor the use of that working tool, considering that it will be containing only information and documentation related to the employment relationship, and therefore information and equipment that is property of the company, not of the employee. And obviously, and very important to have and make the employee note that you have certain compliance programs and you have to comply with certain, for example, anti-corruption policies, etc.
Only to complement, Javier, if it is okay with you, it is very important to say that when it comes to employment matters, and specifically when it comes to the employment agreement, many clients tend to work with specific templates from employment agreements. But it is very important to design and to draft the employment agreement specifically to the position that the company is hiring. As I was saying, many companies like to work with templates, which is okay. But of course, given the importance of the position that we are planning to hire, it will be very important to work, as Javier was just saying, the drafting of the confidentiality clauses and many other clauses that it will be very important for the company to be well protected in case of labor and employment litigation.
That's right. And okay, other document that is very important, obviously, is make sure if you're delivering working tools to your employees, make sure that they sign or execute a reception certificate. This certificate needs to be a very simple document. However, in that document, the employee is actually acknowledging and recognizing that it is property of the company, that it must be used only for the working purposes, and that he must not use that working tool for anything related to personal matters. This document obviously will protect the company in case the employee files any type of claim or action against the company due to the fact that we are investigating or monitoring in a certain way the working equipment. The communication of the internal policies is of utmost importance. As I was mentioning, if the employees do not understand and are not aware of these obligations, it is useless. And the training, a key item. Most of the authorities will consider when conducting investigations due to breaches, potential breaches to the laws, etc., will consider whether the company gave training or not to their employees. In the sense that, okay, you have your policy, yes, but this employee that committed the Corruption Act, did you train him? Did you explain him? Did you help him not to do this? Because obviously, when we talk about responsibility of the companies, and this is a very important item for you to be aware that currently, according to our criminal regulations, companies can be liable for criminal acts committed by their employees or under certain scenarios. Therefore, our obligation as a company is to take all adequate and possible measures to try to prevent the commission of illegal conducts. This does not mean that in any case the company will be responsible, because in last instance we cannot control absolutely everything that our employees do. However, in due time we would need to evidence the authorities that the measures adopted by our company were sufficient to try to prevent any type of these illegal conduct. I don't know, Carlos, if you want to address these matter, labor obligation matters.
Yes, thank you, Javier. It is very important. As I was telling you, the first and probably most important obligation is when it comes to drafting the individual employment agreement. But that is not just the only obligation that employers need to be very well aware of. For example, anytime we talk about compliance matter in Mexico, and Javier was addressing that matter just now, we always talk about internal policies that in terms of compliance that not only are really helpful but really important when it comes to a potential litigation. But when we talk about labor and employment rights and obligations of the parties, it is very important to also have what we call in Mexico the internal labor regulations. The internal labor regulations is pretty much a set of legal dispositions and provisions between the employer and the employees that will have as a main goal for the employer to have a good tool or a very important tool to sanction the employees. And these internal labor regulations need to be filed before the competent labor board of conciliation and arbitration, as opposed to an internal policy that there's no need to file anything before the Mexican courts. The internal labor regulations need to be very well filed before the labor boards of conciliation and arbitration. This will help us to document the interaction between the employer and the employee while the employment relationship lasts. Another very important obligation of the employer in Mexico is the obligation related to the collective bargaining agreement. In Mexico, as you may know, unions hold a lot of power against employers in Mexico. So it is very important that even though the company has only one or two employees, it is very important to also file, just as we did with the internal labor regulations, also file the proper collective bargaining agreement with what we call a friendly union or a white union. If we perform this obligation properly, we will have more than reasonable elements to defend the company against a labor litigation if a union calls us for strike. So as you may see, it is not only related, it is not only the only obligation is not only the individual employment agreement or the internal labor regulations, it is also very important to have a duly signed collective bargaining agreement, duly presented before the Federal Labor Board if it is a federal matter, or if it is a local matter, before the local labor board of conciliation and arbitration. And lastly, but not important, you may be very well aware of that employers in Mexico need to also register each and every one of the employees before the Mexican Institute of Social Security. This is a fundamental obligation, and I can tell you also that with the entrance of the new federal government in Mexico, this will be very well monitored. So this is very important for obligations in terms of the Mexican labor legislation. And also, as you may think, the internal policies that the employer drafts at some point to comply with a number of compliance matters and labor and employment obligations need to be also included in the internal labor regulations. As I was telling you, the internal policies could very well serve for compliance purposes, but not so much for labor and employment matters. If we actually wanted to have our policies duly enforceable, we need to include them in the internal labor regulations. And of course, another important matter here is termination in Mexico. Even though this is not strictly associated with compliance matters, it is very important for you to know that termination in Mexico works a little bit different than it works in other countries. In Mexico, for example, it is very easy to have what we call an unjustified dismissal. Because in Mexico, for example, poor performance or bad performance, it is not a ground for termination. So whenever we have an employee that is not currently performing well, we need to pay what we call in Mexico a full severance package. That will imply 3 months of salary plus 20 days of salary per each year of services, also what we call seniority premium, and of course, any and all benefits throughout the employment relationship. I don't know if you can take it from here, Javier.
Sure, Carlos. Well, it's very important, obviously, because obviously we want to, as a company, we want to have our compliance program, and we want all the employees to comply with this. And obviously, if we have a breach of any of those policies, we want to make that enforceable to impose the potential sanctions, or either, as Carlos was mentioning, the termination of the labor employment relationship. Therefore, the internal regulations will be a key point to make this enforceable, with trying to control as much as possible potential labor risks according to the labor board's criteria. Now, regarding coming back a little bit more to explain some considerations related to what we need to do with our employees' data and what we can do and don't do, we have here a chart that explains the two set of processes. When we collect information from the candidates, and once we have chosen our candidate, when we collect the information to formalize the employment relationship. As I was mentioning, it is important to have a proper recruitment policy that will allow the HR departments to determine when and to what extent we can conduct background checks from our employees. This is not an easy thing because, for example, we can find on the prevention of discrimination laws applicable here in Mexico, for example, that it is not allowed to request certain criminal information. However, on the other side, we have an anti-corruption law that is obliging the company to go as deep as possible to determine that the candidate is the most adequate one for certain key position. And this might be contradictory because I might need to know, for example, if that individual has been condemned or involved in certain criminal matters related, for example, with economic criminal acts or anti-corruption actions, etc. However, even though we might have certain laws that are not very clear and that do not give a proper idea or ground as to what will be considered or not discrimination, it is important that the company fixes a set of criteria as to what the recruitment people can request and cannot request. And for example, there might be some situations in which we want to ask certain information that might be on the line that it could be considered that that information could be used for discrimination purposes. However, it will be important as to in a practical way how you are requesting this information. There will be some things that perhaps, for example, that perhaps it's not that advisable to keep a record that we asked or we requested for certain information, but that still will be useful for the company to make a proper decision. Obviously trying to avoid any discrimination for matters that really are not important as for the position. For example, another matter that is important, medical examinations. These might or might not be justified depending on the position or the specific needs of the company. And it is important to obviously set for that for certain candidates. For example, the company will require to make the medical examination and explain the reason why will be the reason by which we'll be requesting these medical examinations. Now, when we come to employees, obviously it is important for them to understand that the data will be used for compliance of the obligations of the company as employer, to grant labor benefits, to grant him the working tools. The working tools matter is very important, as we were mentioning, for purposes of giving the notice to the employee of the fact that we might monitor or review that working tool for any certain processes. It is important to give them training and obviously for them to understand what is going on and what's happening in the sense of the data protection use and policy. If within your company you are having, you're installing, for example, cameras, you can install cameras, and that implies the collection of additional information from the employee, because we're recording their images as they work, and though we need to consider two things: where we are putting the cameras and for what reason we are using the cameras. For example, video surveillance is something that is justified because we need to keep the facilities of the company safe, and that will also help to keep employees and the people that are working there or visiting there secure from any breaches and all. However, we need to inform that we are conducting video surveillance in two places: on the privacy notice, and we need to put small signs on the areas or zones that we are installing cameras to inform that we are having a video surveillance. Now, there is another set of criteria in which, for example, the camera is not necessarily for security reasons. However, we might install cameras for other reasons, and we want to install that camera directly facing to certain workstation that will be recording one employee. Well, when we want to do that, we need to very carefully review and analyze the reasons by which we will be installing that camera in order to avoid sanctions, for example, for conducting surveillance or videos that were not necessarily justified. In general terms, as a general rule, I would say that the camera should not be facing directly to the employee, but just like a general zone or area, and there must be certain areas for the employees to be, I don't know, to have a free time, and that there's no video surveillance on that area. And the most important point, and that we will start addressing now, is the matter of interviews and monitoring. Because, for example, what we have talked about implementing a compliance program, our policies, our recruitment process, the execution of the privacy notice, but what happens when we actually are facing an infringement of one of our policies and we need to know what really happened with certain employee? We need to know whether if certain whistleblower information is actually true, if it's not true, if we need to sanction an employee, and not only if we need to sanction an employee, but if we need to take preventive measures because actually certain illegal conduct was committed, and then we need to determine as a company whether if we need to give, for example, a notice to third parties, a notice to an authority, if we need to disclose something to an authority to avoid a bigger risk. I will give you one example of this. For example, recently, I don't know if you were aware that Uber faced a breach of information saying that was kept closed. They shouldn't have disclosed that they had a breach of a breach on the security, and then give notice to the individuals that were affected for them to be able to make the proper decision. So investigations will allow us, internal investigation will allow us to either determine whether certain claim is true or not, and to sanction or not an employee, and to determine as a company whether if we need to comply as a company with certain other obligations, or what we need to do to mitigate the risk from the conduct committed by the employee. So just a brief overview of how can I protect the personal data from my employees. First of all, we have discussed having the privacy notice, training the people that will be handling personal information as to what they cannot do, what are their obligations, what are the considerations as to security measures to avoid any breaches. We need to have, as a company, 3 types of security measures: administrative, physical, and technical security measures. And these measures need to be determined or defined according to a risk assessment as to the specific type of information that we are processing or handling. And obviously having our privacy policy, confidentiality agreement, privacy clauses with our employees, and data protection department. This will depend. This can be on legal, or this can be on HR, or this can be within the compliance department, depending on the specific needs of the company. There is no specific rule that applies to all companies. Each company, according to their needs to determine where they open a specific data protection department, or if these functions will be on other teams or departments. So, Carlos, if you want to start with the labor considerations for internal investigations.
Yes, of course. I was just wanting to say, first of all, that it is important to recall that labor and employment related, understanding that labor and employment and compliance and both areas that are very well connected but still pretty different. At some point, there are areas that need to be complement to each other. So it is very important to recall that in Mexico, for some reason, both discrimination matters and hiring processes are not very highly regulated at the federal and the Mexican federal labor law. Even though in terms of compliance, we need to be very careful on what Javier was just addressing on when the type of questions we ask to our candidates and the privacy notice and this many compliance obligation in order for the employer to be absolutely protected. It is fair to say that in terms of the Mexican labor legislation, such processes are not yet highly regulated. And I think this is very important to say, because when we compare our legislation, for example, with the American legislation, that is very well regulated in terms of the types of questions you can ask to a candidate. And of course, when it comes to discrimination matters, it is also fair to say that in Mexico works the exact opposite way. And this is the reason why many companies or many clients tend to think that in Mexico, discrimination matters are not as complicated as in the U.S. or as in other jurisdictions, which is kind of a lie if we think it at some point, because Mexico is recently taking very seriously the discrimination matters, and the whole process, the whole recruitment process that a company needs to have for an employee to be hired ultimately. And as I was telling just minutes ago, with the entrance of the new federal government, we can very well expect that discrimination matters and compliance issues and any and all processes we follow to hire a candidate will be taken a lot more seriously. So I think it is very important for you to know that even though our legislation, it is not as aggressive as the American legislation when it comes to discrimination and hiring processes, that doesn't mean that we need to be that we can adopt like a light attitude when it comes to these matters, because as I was telling you, it is not only a labor and employment thing, it is more actually a compliance thing. So this is very important for you to know when you're, for example, drafting your internal labor regulations. Javier was just saying that we may face several situations when the company needs to sanction an employee, for example. And as I was telling you before, you can very well have a number of internal policies and a number of code of conducts which are perfect for compliance matters. But as long as such policies are not well included in the internal labor regulations, for labor and employment matters will not serve the purpose. So our job at some point is to mix the internal policies of the client and include them in the internal labor regulations. Even though, as I was telling you just now, our legislation, it is not as aggressive as the American legislation or probably related to other European legislations. Truth is that we need to be specifically right now at this moment of history very well aware of how discrimination could affect our employees, and also, as Javier was just saying, be very careful with our data privacy policies and, of course, including them in the internal labor regulations. Javier, I don't know if you want to complement here.
I think from that side, you have addressed everything, Carlos. So we can now start with the considerations regarding internal investigations. So there are two options when we are conducting an internal investigation. The first option is, and we ask ourselves, can we conduct an internal investigation to an employee when there is no previous acceptance by the employee, for example, as to the fact that we are monitoring and or reviewing our working tool? Well, the considerations here are, first of all, that still, even though when we don't have the acceptance of the employees, the property of the working equipment is of the company, not of the employee. Strictly speaking, according to the federal labor law, he should use that equipment specifically for purposes of the employment relationship. And, well, obviously it is important to consider the fact of where if we had our internal regulations accepted or not but by the employee. And here, what I want to say is that, yes, we can conduct the internal investigation. However, obviously, if we face some type of claim or demand from the employee for having access to his computer without him knowing, because when we conduct an investigation, we can either do it with the employee or without the employee, depending on the specific needs and the specific relevance. If we need to do it without the employee in order to avoid any deletion or destruction of important information. So if we do this with the employee, perhaps the employee might get mad and say, hey, why you're accessing to my computer without my consent? And then if we did not have either on the privacy notice or the delivery certificate of the working tool, and though any type of express acceptance or consent, we can do this. We will see what are the considerations and the recommendations to conduct this investigation. However, we are facing a bigger risk, because even though there are sufficient legal grounds to present a defense for the company, well, some authorities might in some time issue a criteria where we should have asked for the corresponding consent. However, in our opinion, there are sufficient elements to determine that even though we didn't have the corresponding consent or notice, well, here what we're doing is reviewing a computer, for example, that is property of the company, and the password and the access code, and though all of those matters were given by the company to the employee. Therefore, we are not breaching any private or internal communication of the employee. Now, What happens, obviously, when I have the ideal scenario is when we inform it, when we started their relationship, or at any point in time when we inform it, the employee, that we were going to conduct investigations from time to time if required by the company. Another option, for example, is that we can start an investigation informing the employee that we will conduct the corresponding investigation. So what are the risks of the non-acceptance of or the lack of notice of this situation? Well, the employee could try to file for civil, criminal, and labor claims. However, the idea is, for example, that if you don't have consent, with the recommendations that we will give in a couple of minutes, is that you do it as controlled, as much controlled as possible in order to avoid this risk. And obviously, from now on, it is important to implement this type of notices to avoid and mitigate risks associated to investigations. So what are the considerations when conducting an investigation? You need to have, as a company, an internal process. This is to avoid any type of questioning as to, okay, why you are conducting this investigation like this? Did you have a process established or not? If you have a process established, the process will be more transparent, and it will be easier to evidence to the authorities that all that the company was doing was according to a specific process in which we had a proper justification for the investigation, that the investigation was carried by a limited number of people in order to avoid disclosures and in order to avoid that all the company will know of the situation, etc. This must be as contained as possible. The participants of the investigation should be subject to confidentiality obligations, specifically for their functions as parties to a certain internal investigation. Generally, for example, these investigations are carried out by the compliance department along with other departments that might be involved. For example, if we need to retrieve information from an electronic equipment, we will request the support from the IT department. But we need to keep this as narrow as possible in order to avoid people that do not need to know that are aware of this situation. Obviously, when we're investigating, we might find information or data that is not useful for the investigation. For example, hey, we found on the computer a set of pictures that were uploaded by the employee and of his vacations with his family. So perhaps he shouldn't have done that, but that might not be that relevant for the investigation. So as a company, let's delete or not keep any information related to that employee that it's not strictly necessary for the corresponding investigation. Another important item is, once you have conducted that investigation, it is important to document the result of the investigations. This is just a general recommendation. Obviously, for example, if you have an investigation that ends on, okay, nothing happened here, this was just false information, and though perhaps in your policy you will determine which cases must be documented, which cases can be not documented in order to avoid too many paperwork and though, but this needs to be properly defined. And from a labor standpoint, and Carlos, I don't know if you want to address the potential sanctions that can be or consequences that can happen when you find out, for example, that certain employee indeed breaches any of the policies of the company.
Yes, of course. As I was telling you before, all policies need to be very well included in the internal labor regulations. So if we actually have the internal labor regulations duly filed before the labor board and the employee breaches one of the obligations that were agreed between the parties, it'll be easier, not as easy as we would like, but easier to probably terminate the employee eventually. For example, if that is the company's will, and of course that will help both the employer and the employee to have very well aligned any and all rights and obligations of the parties. And of course, whenever there is a breach of an obligation, either from the employer or the employee, as I was telling before, the employee could very well face termination, and of course, the employer could be potentially liable for any fines that the Labor and Employment Ministry will be eventually revising through the proper mechanisms. But just to complement what Javier was saying minutes ago, and just to close this matter from an employment and labor perspective, it is very important to recall that whenever conducting an investigation internal process at a company, from a labor and employment standpoint, it is fundamental to document such process through what we call in Mexico an administrative act. An administrative act is not anything else than a written warning or a written investigation when the employer could address any and all problems with the employee, but giving the employee the right to defend or to say something that him or her will find convenient for his or her own interest. This is very important to perform because in Mexico, as you may be well aware of, our legislation is very overprotective of the employee's best interest. So whenever conducting an internal investigation, even though Javier already explained the compliance matters, from a labor and employment perspective, it is fundamental to document such through an administrative act and to give the employee the possibility of arguing whatever him or her thinks that is fundamental for his or her employer and employee rights, Javier.
Great. And just to wrap up with this whole presentation, it is important for you to consider, obviously, what are the company's responsibilities by the employee's behavior. We need to understand that what our employees do might impact, obviously, not only on the personal responsibility or liability of the employee, but also on the responsibility of the company. And we can face the imposition of fines, temporary disability, suspension of activities, dissolution, and prison of certain officers in certain specific scenarios. What are the factors that might mitigate our responsibility as a company? And obviously, the investigations, conducting internal investigations and having the proper compliance program will allow you to identify risks or situations that need to be addressed, correct those situations, and therefore prevent for further situations that might put the company in a risky situation. And we need to take action of situations that we are already of our knowledge and that we already know that might put the company on a risky situation. Mitigating factors when the company is already facing potential responsibilities or liabilities due to conduct of our employees are obviously the collaboration on the investigation by the company with corresponding authorities, having the proper policies and procedures, and supervision and control mechanisms. And in some cases, obviously, going with the authority prior to the authority starting the investigation, that might help. And that's something that needs to be determined and assessed on a case-by-case basis, considering the specific situation and the type of potential risks or sanctions that the company might face. And it's for real right now, the laws and many laws in Mexico will state nowadays that having a compliance program and a supervision and control program will benefit the company, but if you don't have it, it might be bad for the company in terms of responsibilities. So this is all from our side. We don't want to take more time than what was scheduled. So we will be glad to answer any specific questions you want to address either I don't know whoever has any time right now, or if you want to contact us directly, we will be glad to answer and respond to any questions you may have.
Thank you, Carlos. Thank you, Javier. That was wonderful. We were truly blessed to have a chance to listen to you speak today. Before we sign off, I just wanted to remind each of you that in the next few days I will distribute a copy of this presentation, a recording of the webinar, as well as both of their contact details. So if you do come up with a question or something comes up in the future, please do not hesitate to reach out to them directly. With that, did you have anything else?
Not from our side. Thank you very
Not
much.
from our side. Thank you very much.
Fantastic. Thank you. Thank you again for joining us. Have a great day, everyone. Bye-bye.
Bye.